Hi, everybody. Good evening. Nate Eaton here. It's time for Courtroom Insider. Thanks for watching, coming to you from Phoenix today, where we had a very short court day, but things are definitely progressing in the Vallow Daybell trial as we get closer and closer to the finish line, which should be next week if everything goes as scheduled. Thanks so much for watching tonight. Would love to know where you're watching from. And I want to wish you a happy Easter weekend. It's already here. Easter is here, and I'm headed home and excited to be with my family and then turn right back around and come back on Sunday for the big day on Monday. Here's what we're going to talk about tonight. We have jury instructions. That's what they're called. And we'll have learned a little bit more on whether Lori will testify in her own trial. The judge kind of pinned her down today and said, we need to know, are you testifying or not? We're going to have defense attorney Alan Browning here in just a minute, talking about defense strategies, when a defendant takes the stand versus when they don't. He has some valuable insight. And then prosecutor Rachel Smith. I mentioned this last night. So many of you sent questions and some really good questions, by the way, questions I personally have had and wasn't quite sure what the answers were. Rachel's going to answer them. We had a good conversation a little bit earlier, and I hope that you gained something from her. What is next in the trial? We will talk about that. Of course, we will remember Charles and answer some of your questions and have a few shout outs. So with that, let's jump right into it. Today, the jury did not show up to court. It was just the defense, the prosecution, and the judge. And what they need to do is all agree on the instructions that the jurors will receive on Monday. So they go through, and those instructions are not public. We don't know what's in there. So it was kind of like eavesdropping on a conversation, but you don't really know the context. We know some of the context, we don't know a lot. So they would go through the pages and be like, okay, on page 4, this rule, I think we should change the word here versus here, or does this definition match this? Things like that. And if you want to go back and watch that, go for it. I wouldn't say it's the most captivating stuff we've seen in the court, but you might be interested, and feel free to watch it. I won't bother playing any of that tonight. What I did want to play is a little clip about the judge asking Lori whether she's going to testify or not. Here's what she had to say.
Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. And then the procedure will be on Monday. When the jury comes in, I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions.
So she will not be taking the stand. I mean, I guess until she officially says, I rest, the defense rests, she could change her mind, but then the judge said all of these instructions they went through today could be modified. So I don't think she's going to take the stand. But we did get a little bit of insight today as far as Brandon's trial and the scheduling for that. That's the next trial that's down the line. Prosecutor wants it set for quite a bit of time, and the judge pushed back a little and said, listen, you asked for 5 to 6 weeks on this particular trial, Lori's trial. We got it done in 7 days. Which is crazy to think 7 days. Feels longer, but it really has been 7 court days. Here's how that interaction went.
For now, we're setting the final trial management conference May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be,
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
all right, the state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date or they're deliberating later. So I would ask they be screened through July 3rd.
11, 12, 13. That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June, so
What's that?
didn't we screen these jurors through the 15th of June? So,
No, May.
I'm sorry, of May, so we had,
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal, just. and
We can
that-
confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town.
So now you can plan out your June, at least the beginning of June. Plan to be here with East Idaho News watching this next trial. I'm really going to be fascinated with this next one, especially because Brandon is the one who survived. Brandon is alive. Could you imagine had they succeeded in killing him? Another homicide? Ugh. Anyway, that one should be an interesting one. So we'll stick around and we'll do Courtroom Insider for that too. That's basically what happened today. The judge, after they went through all the instructions, he said, I need to go back to my office. I'll print them off. I'll give you a copy, Lori. You can review it this weekend. I'll email them to the other parties. And then the attorneys left and they will prepare for Monday. So right now I want to bring in Alan Browning, and I do want to acknowledge Browning Law is the sponsor of Courtroom Insider. They have been a great sponsor. They don't control any of the content. They don't control anything I say, but they are just helping us bring this to you every night so that I can be here in Arizona. I spoke with Alan just a minute ago about defense tactics. We hear a lot from prosecutors because they are the ones that bring the case in the courtroom. And at least with the Lori Vallow, Chad Daybell situation, we've heard a little bit from the defense attorneys. John Pryor for sure. We didn't really hear anything from Lori's first attorneys. And of course, in this case, we heard Lori cross-examining, but we didn't hear her actual defense. So I chatted with Alan a little bit about that, and here's what he had to say. Alan, good to see you. Tell me, just first of all, your overall thoughts so far now that we've seen Lori Vallow Daybell represent herself over the past few weeks.
What I see is somebody play acting to be an attorney. She's learned some legal phrases. She has apparently read some books. She's familiar with having been tried for murder, for several cases of murder. She is familiar with some of the motions that are brought, so she thinks she could just go ahead and bring them herself. The difficulty in this case is that the best defense Lori Daybell has is that she's crazy, but yet she's trying to act like an attorney who knows everything about the law and trying to basically put on this front like, she's a very competent attorney. At the same time, she's, her best defense would be that she's crazy. And people that know her apparently will say that, yeah, she's crazy. But she's kind of thrown that defense out the window because she's raising all these legal arguments that kind of sound good. They don't have any substance to them because she really doesn't know what she's doing. Yeah, we've got a crazy person who is crazy, but at the same time, she has a certain level of intelligence and cunning, if you want to call it that, as well. This is an evil, cunning, crazy, but somewhat, not totally stupid, but foolish.
Do you think she could have gotten away with perhaps bonding to the jury more? Not saying they haven't found her guilty or anything. I'm not saying that, but maybe blaming more on her brother. Or
that's the only.
Go ahead. Yeah.
Yeah. This is a conspiracy trial. She didn't pull the trigger. So in a conspiracy trial, the best defense that she's got is to put all the blame on her brother and say, gosh, my brother just is, he was an evil man. He's dead. He's just not here to testify, and there's nobody here testifying against me. The brother, maybe he heard me say some awful things about my husband. That I hate him, and my husband's doing awful things to me, and my brother just got the idea. Well, gosh, I will take care of your problem for you without there being any agreement. In that case, she'd be non-guilty, even if her brother thought he was doing her bidding, by knocking off Charles. But she, that would be the best defense that she's got. Not saying that she has a defense. She's going to the gallows as far as I'm concerned.
Okay, so a lot of people really wanted her to testify. If you were her attorney, would you have advised her to testify?
Here's the deal with an attorney telling his client to testify. There's several things at play here. Number one, if you know your client is going to lie, you are prohibited from allowing your client to testify. They may fire you, but under the rules of ethics, if you know your client is going to lie, you cannot put your client on the stand. All you can do is poke holes in the evidence that the prosecutor puts before the jury. And I will tell you that the temptation to put a client on the stand knowing that they're going to lie is too much for many, if not most, attorneys. I have seen attorneys put their clients on the stand to tell a fairy tale, even though they know that they're going to tell a fairy tale. I've seen that happen before. It is a very tough thing for an attorney to do. You got to have a lot of fortitude to restrain yourself from putting a client on if you know your client is going to lie. But if I did not think that my client was going to lie, I would want to put my client on the stand. And one of the main reasons, statistics show that in cases where an attorney does not put his client on the stand, 90% of those cases are convictions. So you can figure if your client does not take the stand, your client will be convicted. So what are you going to do?
Interesting. Okay, so she didn't take the stand. She doesn't plan on taking the stand, but she has this weekend to prepare her closing argument if it's not already prepared. We know the closing argument isn't evidence, that the jury is told this isn't evidence, but what type of things can go into a closing argument, and how effective do you want that argument to be?
Oh, it's everything. Several things go into making a closing argument. There's a real art to it. There are seminars and long seminars and classes and everything on how to put together an effective argument. And I was actually able to sit in on a seminar taught by one of the Watergate lawyers and talking about, putting together effective arguments. A couple of things. You don't want your argument to be longer than 45 minutes. So you might have your audience check that, see just exactly how long are these arguments are being made. The rule of thumb is 45 minutes is about all the jury, wants to hear. If you're going on longer than that, you're wasting the jury's time. Another a key thing in closing arguments, whether it be civil or criminal, is what we call promises kept. And that means that when you start your trial, you have opening statements. And in an opening statement, all you're allowed to say as the attorney is the evidence will show this, the evidence will show that. You can't make an argument, as to, weighing evidence or anything like that. All you can tell the jury is what the evidence will show. And at that point, you tell the jury what evidence is going to come out in favor of your side of the case. And in closing argument, that's when the jury wants to know, have you kept your promises? You told us you were going to show this, this, and this. You told us that there was going to be no evidence that there was an actual agreement between Lori and Alex. You told us, these various things. You told us there was going to be, no witness that Lori had actually committed this crime. And they want to, so at closing argument, you want to remind them, okay, that's what we showed. We showed these various things. Another thing about closing arguments, something prosecutors always do. The judge will give the jury instructions on how they're to decide the case. He'll instruct them on the different elements, of the offenses. And they might have 9 different elements that they have to prove. The prosecutor will go over each one of the 9. They'll put a chart, in front of the jury and say, element number 1, this is what we have to prove. We prove that because of this. Element number 2, we prove that, because of this. It was in Idaho. It was in this county. It was, the person did die. The person did die on this date. All these various things that they have to prove. And what the defense attorney will do in response to that, the prosecutor will have, say, maybe 8 of those 9 things are, everybody knows that. 9th will be the key one. The prosecutor in his argument will try to get the jury nodding along, saying, oh, yeah, well, I guess if they got 8, they must have all 9. And what the defense attorney does is brings the jury back to, wait a minute, this is not a case about 9 elements. It is a case about 1 element. Was there an agreement between Lori and Alex? That is all you need to be concerned about. And they need to focus on that. And I have actually spoken with jurors, in voir dire, where we're choosing a jury. I've had 114 jury trials. And when you're picking a jury, you can ask the members of the jury what their feelings are about different things. And I had a recent trial when I asked one of the jurors, what if the prosecutor, has 9 things to prove, and, they're 8, or, they've really proved these 8, you're not sure about number 9. What do you think? And I've had, some of them say, well, probably proved all 9. I said, well, wait a minute, it just establishes a fact. They proved 8, and number 9 is, well, maybe yes, maybe no. That's called reasonable doubt. And there are, the prosecutors will try to get the jury to think in that mindset. Okay, we're nodding the head, yeah, 1 through 8, no, so number 9, okay, that must be there too. It must follow because 8 are there, 9 must be there too. So the defense attorney needs to bring the jury back and say, this is a case about 1 issue. Did they prove this issue? And then you give all the reasons why, from the evidence, why that is lacking. Because this kind of a trial is all about reasonable doubt. If there is a reasonable doubt, they must acquit. And that's something you have to, that doesn't just start in closing argument. That starts when you're picking the jury. That has to be ingrained in the mind of each one of the jurors that this is all about reasonable doubt. If there is any reasonable doubt, that they must acquit. And that's a hard thing for people to do, especially if you have a heinous crime, that has occurred. It's tough, for jurors to think in terms of reasonable doubt. But for the most part, I think the jurors really try to follow those instructions, as hard as it may be in some cases.
Well, it'll be fascinating if maybe Lori Vallow is somehow watching this. You may have given her a few tips if she prepares those closing arguments. Alan, thank you so much. Is there anything you want to add?
The only thing I would add is I wouldn't want to touch this defense with a 10-foot pole. I told one of her attorneys earlier that I'm glad that I'm not the attorney on the defense on this case. I like to like my clients. Let me put it that way. I would not be comfortable at all, being the defense attorney on this case, and so for that reason, Lori has spared somebody a lot of pain by doing it herself. And I think one of the questions you had before was why might a person in the defense not call any witnesses?
Right. Oh, yeah. Why would that be?
Because they're stupid, or they're incompetent, or they have no evidence. Those are the things that I see in this case. In general, is there a time when you would call on witnesses? It would have to be a case where you were convinced. I mean, it's very risky to do that. It's probably malpractice for a defense lawyer to do that. But the only time you'd even consider it is like if you're convinced that the jury hates the victim, or that the jury hates the main witness, or that the jury hates the prosecutor. I had a case in another county in Idaho about 6 or 7 years ago where we were in the course of picking a jury, and the prosecutor says to me, "I just want 12 people who don't hate me on the jury." He says, "That's all I want." And that was an interesting case. Yeah, my client was acquitted in that case, actually.
Well, I guess when you heard that, you're like, okay, I'll take it, please, good. And my thanks again to Alan Browning for joining us here on Courtroom Insider, bringing his insight and perspective as Lori Vallow continues to defend herself. And she says she plans, it sounds like as of now, she's going to defend herself on the next one too. She could switch. She could ask her advisory council to step into the main chairs. That would be fascinating if she decides to do that. All right, let's pivot over to my conversation with Rachel Smith. Rachel, for those of you that are new here, Rachel Smith was a special prosecutor on the Chad Daybell Lori Vallow matter in Idaho. She sat through the trials with Lori, the first Lori trial. She cross-examined, or she questioned witnesses. She helped come up with the theme of money, power, sex. She's very experienced, has done hundreds of homicide cases, dozens of death penalty cases, and she is also a special prosecutor on another case we're following in Idaho, the Jeremy Best case, which just reached a plea agreement. He's the man who killed his pregnant wife and then took their toddler and killed their toddler, and he was found naked in a sleeping bag. And it all happened over Thanksgiving weekend. Just a horrible, horrible story. I say killed because he did plead guilty, but should he change his mind, it would be allegedly, just to clarify that. So Rachel Smith knows what she's talking about. She's been following this case closely too, from her home and from different places where she's working on special cases across the country. And so I caught up with her today, and many, many of you sent me questions. So many of you sent me questions. I was able to ask them to Rachel. Here's our conversation. Just first of all, your overall takeaway as to how the trial went.
The trial of Lori Vallow was clean, concise, and directly focused on Charles Vallow. The prosecutor on this case, Trina Kay, did a good job of trying a straightforward, uncomplicated, as much as you can uncomplicate this case. The issues are going to be very clear for the jury. It's really going to just come down to whether jurors can take circumstantial evidence and convict someone of conspiracy to commit murder. That's the Trina's challenge. That's going to be what she's going to have to connect those dots for in closing arguments. And this is a circumstantial evidence case. This is a complicated conspiracy that the prosecutors tried very cleanly. On the other hand, Lori Vallow has done an excellent job of being her own worst enemy. She has shown everyone she's smart, she's quick thinking, she's arrogant, and she's capable of pulling off a conspiracy. So her decision to represent herself candidly has become some of the best evidence the prosecutor could hope for.
Interesting. So you're saying that the jurors really saw who she is.
Yeah,
She is
yeah.
the
And
person.
yeah, absolutely. Because jurors go into a case, especially with mothers, wives,
You're right.
there is an implicit bias of people that's still out there on gender. It can be very difficult to convict women of certain type of crimes. Lori attempted to play the abused wife or the put upon wife, the targeted wife. She failed. I believe she's going to pay for that. And so in this situation, unlike in Idaho, you had a natural, would a mother really do that? Right? Would, as a mom, what mother could do that? And I remember thinking that at times myself, knowing the jury sitting there thinking, would a mother do that? Right? So here, this jury presumably does not know about the children, but they're going to think is a wife going to do that? Is really, why didn't she just divorce him? How do we know she really wanted him dead? Right? They're going to be thinking that. Had Lori not been her own lawyer, her lawyers would have gone after and probably would have gotten more of the evidence of the allegations of the steroid use, the allegations of his anger at her, his frustration at her. Um, and and so Lori just showed everybody what she's capable of and that she's not crazy, right? She may have bizarre beliefs, that is bizarre thought patterns. That's different than crazy,
Hmm.
right? Evil sounds crazy to people who are normal and have a moral compass that points north. That sounds crazy. Sometimes it's just evil. And so her actions, her demeanor, her conversations have shown us who Lori really is.
Okay, so one of the main questions I've gotten all along is why can't the prosecutor tell the jury about Tylee and JJ and Tammy Daybell?
And in this situation, the murders of Tylee, Tammy, and JJ happened after the death of Charles. So when conduct happens after a particular crime, it can be very difficult to admit that information to show what somebody did before. It's the idea that the conspiracy to kill Charles would have occurred before Charles died. So, unless the court allows that sort of definition of conspiracy to be expanded to a greater overall conspiracy, then the court's not going to let it in.
Now, why would the judge say that if Lori, he told her at the beginning, if you decide to take the stand, he may need to tell the jurors about her convictions?
Under laws in most states, a person's felony convictions and or convictions related to dishonesty come in to impeach their credibility. That
Oh,
is longstanding principle of law. The court clearly was warning her that you're a convicted felon, you're a convicted murderer, and the jury may be entitled to hear that. He was probably going back and forth on, the convictions happened after what happened to Charles, so maybe he should keep it out. But I think in the end, she would have been subject to cross about her previous convictions, and that would have opened the door to what happened to JJ and Tylee.
are you surprised she didn't testify? Well, at least as of now, she hasn't testified. She could change her mind on Monday.
Lori could change her mind, but I am not surprised that Lori Vallow didn't testify. One, she was going to open the door, I think, to lots of things that has been successfully kept out or not even offered. And two, Lori likes to be in charge. Lori likes to be in control. Lori wants it to be the Lori show. Had she testified, she would have been subject to cross-examination by the prosecutor. And that prosecutor will be primed and ready and fingers crossed want it to happen. But in reality, Lori's not going to let anybody else be in charge. And on cross-examination, the person cross-examining is in charge. Lori's never going to let that happen.
I know so many of us wanted because she really hasn't answered questions to anyone. If she were to take the stand and the prosecutor asks her these direct questions, What would happen if she said, I'm not going to answer that?
It would get used against her in closing argument. It would be very bad for her. Two, with a regular witness, the court can hold someone in contempt for not answering. What's he gonna do? Jail Lori again?
Right.
So I think reality, Lori taking the fifth or saying I won't answer that after a period of time would only hurt her credibility in front of the jury. And if she's got to stand up there and do her closing argument, she doesn't want her credibility undermined. I think her closing argument is going to be Lori testifying. And I think we're going to hear Trina Kay do some objecting, saying she's testifying.
How do you think the judges handled this? It's kind of a tricky situation with her. A lot of people have been like, he needs to quit giving her legal advice, but he's told her, I can't give you legal advice. And he's kind of remained out of the spotlight. Sometimes judges jump in and he's
Yeah.
kind of just, not in the background, but he's just letting things run.
The judges handled this with we call it pro se where I practice. Other places call it pro per, but
Right.
the pro se defendants are some of the hardest situations for a member of the bench and candidly for opposing counsel. You are very mindful that you have to follow all those rules. And so in this case, the court is paying attention. It's my understanding he's an experienced defense attorney prior to being a judge. He's a well-respected judge, talking to colleagues of mine from Maricopa County. He knows where those lines are. His experience as a former defense attorney, he knows where she is getting herself in trouble. And he's done some nudging there subtly to protect the record. The court has two responsibilities: to protect the party's rights and to protect the record so that a just outcome can be had and can be withstand scrutiny from higher courts. And so when the judge has jumped in, he's done it subtly. He's done it by and large outside the presence of the jury. And he's done it in a way that makes it really clear that she wasn't railroaded. She was making an informed choice. And a person's right to counsel is your right to make informed choices. If you're your own lawyer, you don't get to complain that you had a bad lawyer as long as the system and the trial was fair. And that's what this judge has done.
Another huge question we've gotten, and I kind of addressed this last night with your help, but I want you to say it in your own words. The video of Charles going to the police for help, I believe it was January, February of 2019. We've seen it. Why didn't they show that?
And this is really hard for victims and victims' families. When a person has passed away, their statements are hearsay. There's probably no better defined situation than the statements of a victim that are recorded or written down by someone else than the statements of a victim that are put on recordings. And so Charles's statements to law enforcement are hearsay, classic definition of hearsay. There's a couple of exceptions, none of which were attempted in this case. So it is not admissible. I've had other cases where the victim's statements are not admissible unless I could find an exception to the hearsay rule. Doesn't, to my knowledge, I don't have evidence that the prosecutor tried. If she did, it would have been behind the scenes and with a hearing with the judge outside the public presence and outside the presence of the jury for many reasons. That's done to protect the right to fair trial of both parties. So Charles's statements to law enforcement are hearsay. The court has not found that there's an exception that lets them in. So like in every other case, hearsay is not admissible.
Same with Tylee's police interview at the police station.
Say Tylee's statements to the police the day Charles were killed are hearsay.
Okay, let me go through some questions that our viewers sent in. I got a lot over the night. Someone mentioning the video, we talked about that. What would happen if Lori Vallow wanted to call Chad Daybell as a witness?
Lori could she'd have to get him served and get a subpoena served on him to make him appear. His lawyers would quickly respond with a motion to quash and assert that he has a Fifth Amendment privilege. That would all occur outside the presence of a jury, and the judge would not allow it in. You cannot call someone for him to just take the stand and take the fifth. There's no way Chad Daybell is going to take this case or somehow implicate himself in Arizona. So he wouldn't have anything good to help her with, and his lawyers wouldn't let him, and the judge won't make him.
Here's my question for Rachel. This is from Tracy. To the jurors, it looks like Chandler didn't charge her for years, but there's a good reason for that we know that they don't. She was on the run and then either in a mental hospital or preparing for trial in Idaho. So it may look like they dragged their feet for years. Can they explain why they didn't charge her for so many years?
Well, they did charge her. So I forget, what is the case number on this, Nate? Do you remember?
I believe it's CR 21.
So the jurors will hear the case number, which will tell them when it was filed. So they know going into it that it was filed in 21. So the fact that things take a long time to go to trial, jurors just realize that. And Lori has not really driven that point home. So I don't think the jurors are going to worry about it. People know that the system takes a long time to go to trial. And the fact that they're there on a case number starting with 21, 2021, they're going to know that the charges have been around for a while.
The other day, Lori mentioned about the grand jury, and the judge immediately told the jury to disregard it. Why?
The idea is, and the case law is like this across the country. The idea is if the jury hears that a grand jury has already voted to have charges proceed, that somehow it can lessen the burden on the state, that it can make the prosecutor's job easier because another jury's already found it. So the judges, I don't know of any place where the judge lets a lot of discussion about grand jury into the case without a really good reason. Because the idea is, hey, another jury's found her responsible or found enough evidence, so maybe we should too.
Dawn says, I like Trina Kay. Some of her questions seem very leading with her own witnesses. Do you think if Lori had more competent attorneys helping her, they would object? They would object to those questions.
Trina is leading. I've noticed that there is a lot of leading. However, it's kept the case moving. It's not inappropriate. It's very focused on what the obvious answer is going to come from the witness. So I don't think any of it is a problem on appeal. When you know the other side knows how to do it, you often let them go because it just slows it down. It makes it look like you're hiding things. So I think we would have seen some objections from a defense counsel, not a lot, because they know Trina knows how to ask the question correctly. Most of these witnesses have already testified, so they already know what they're going to say. Trina's just moving it along. I think we would have seen some, but nothing happening is something that's going to cause a problem on conviction. But I was a little jealous at her ability to lead some of that through the text, because text messages can get dull. That's a hard testimony to make jury see as compelling, and I think Trina did a really nice job with that.
I remember in Idaho, you guys had the witnesses pretty much read every text, didn't you?
Mm-hmm. Yeah, because we wanted them on the record, and the way the court wanted it done. It's a style choice. You're seeing different prosecutor style choices. I try really hard, especially with witnesses like Special Agent Doug Hart, now, Chief Deputy Doug Hart. If I could have just stood up there and let Doug talk, I would have, because he's just such a great, compelling witness. He knew this case backwards and forwards. So I don't lead witnesses like Doug Hart. I want him to do the talking. But Trina was trying to move the case along. I suspect Nate Duncan was still not feeling great.
Yeah.
And when you have a witness who isn't feeling well, who isn't, maybe at the top of their game, I mean, his testimony was great, don't get me wrong, but your people, if they're not at their game or they're struggling, that's when you'll see a lawyer lead. They're trying to move it forward and trying to help their witness get through it.
Why do you think, I don't want to say they downplayed the sexy text messages, but they kind of did. I mean, they really minimized it versus in Idaho. Was that just, again, a choice of getting minimal, make it clear they were having the affair rather than sensationalize it, I guess you could say?
Well, yes, that was a trial strategy choice of the prosecution. You've got to remember her focus is about the death of Charles. Chad isn't charged. And they haven't alleged overtly that Chad was part of the conspiracy.
Mm-hmm.
So the more you put in there about Chad, his motive, his actions, the more you give somebody a chance to think, well, maybe Chad and Alex did this and Lori didn't, right? So you want to keep it super clean. You want to make sure that Lori, the jury rightfully sees Lori's role in all this, which is a key leader, a key conspirator who candidly set her brother up with these beliefs that Charles had to die. The more you inject about Chad's motive as well, Chad's role as well, the more you muddy the waters on somebody who's not charged. Those sex things weren't just to sensationalize, it was to show the level of manipulation that Lori had over Chad.
Right.
So sex was a manipulation tool that Lori and Chad used on each other. It was mutual manipulation. And that sex was just one more tool in their arsenal.
Sensationalize was a poor word on
Yeah,
my.
yeah, no, I'm with you.
I meant maybe maybe we sensationalize it, but it did come out, and I know people. The lady next to me is like, "Get ready for the storm." Yesterday,
Yeah.
didn't even go there.
No, because it wasn't about Lori leading Chad. This
Right.
trial wasn't about Chad.
Right. Question for Rachel. This is from Carter. In many trials, I hear the judge instruct the jury that what the lawyers say is not testimony, and that only what the person on the witness stand says is. How does that work on a normal cross-examination or on such leading testimony that we have had on direct in this case? Does that instruction literally mean ignore the attorney's words? Or if they ask a question and someone answers yes, then you can take the words of the question to imply the meaning? I'm guessing it has to do with the latter, as otherwise 80% of the evidence in this case is yes or no. I can't wait to hear your answer.
You answered your own question. And so the answer to that is when a witness adopts part of what the lawyer says in a leading question, that becomes those witnesses' words. So if the witness says no, then the jury disregards the whole thing. If the witness says yes, then those words become the witness's words. It's about what the witness has to say. And so if the witness has adopted a leading question, those questions become the witnesses.
Can you ask Rachel some questions about the appeals process? Does the defense file the first appeal, or does the state automatically file as a, quote, audit of the trial?
Oh, that's a great question. No, the state does not file anything. The burden will be on Lori, and hopefully her standby counsel help her with this, to file their notice of appeal. Almost every criminal defendant files an appeal. It doesn't matter whether they plead guilty or they're found guilty, they all appeal. The one exception will be is if Lori decides I'm done, I don't want to stay in Arizona, I want to get back to Idaho. So it may be that as soon as Brandon's case is done, Lori doesn't file appeals from Arizona and just gets herself back to Idaho. But technically the burden's on the defense.
I know that Rachel doesn't know the answer to this, but I'm curious. Does she think that Lori fired the second shot into Charles's shoulder?
I don't know the answer to that, but I will tell you that would be inconsistent with the physical evidence. I know there's a degree to which people who feel so betrayed by Lori that they want to believe she pulled the trigger. Alex was the person who did her and Chad's dirty work by and large. I don't believe Lori pulled the trigger. She wanted to get out of there as quickly as possible, to get Tylee settled, to get their story straight, to make sure JJ was in a place where he wouldn't be questioned. So there was a reason Lori left. There was a reason Lori took JJ to school, got him his food so he didn't go to food school hungry. There's a reason she set that all up. And Lori didn't do her own dirty work. That was Alex's job. So my belief is that Alex did the shooting. They're too close in time together. Charles was a strong, big guy, and when you're shooting somebody to make sure you take them down, you don't pause to hand a gun to someone else.
Chelsea says, do you think they pre-planned everything the night before, like the visit to Walgreens and the visit to Burger King? Or do you think that it unfolded that morning knowing Charles would be shot and then they just went with what happened next?
I think it's the second piece that Lori and Alex planned for Charles to die. As we've seen in a couple other situations with them, they plan, but they aren't detailed people, right? They don't turn off their GPS. They leave their fingerprints on bags. They leave their DNA at scenes. So this was Charles needed to die that day before some sort of intervention. They needed to die before he could do more to reach out to Tammy. So he needed to die that day or close to that day, but they didn't go too far beyond that with details. I think they really they left the house without shoes on, or Tylee did. So they had to get Tylee shoes because it would look weird for Tylee to be walking around without shoes on. They needed shoes to get JJ in, and JJ couldn't go to school hungry. So I think she dealt with the cards she had and cleaned up the pieces she had. And they also needed time to kind of get their story straight.
Devin wants to know what you think the strongest piece of evidence is that the prosecution presented.
Lori's text. And, multiple of those texts show Lori's intent, motive, and the conspiracy. This is technically what they call a circumstantial evidence case as to Lori, not as to Alex. So they needed Lori's words and participation and desire for Charles to die, and that's what they have.
Very good. Rachel, thank you so much. Is there anything you want to add?
No, I'll be very interested to see if Lori changes her mind and testifies, but I really don't think she will.
How long do you think the jury will be out with this?
You know what? And I couldn't see the jury, so I don't have an answer to that. If you have one or two who struggle, and this is going to be the prosecutor's challenge, a conspiracy case is hard because it's conviction for thoughts and words. And two, conspiracy case based on circumstantial evidence. You don't have, go shoot Charles or shoot Charles this day. You don't have a direct admission. You don't have direct, she pulled the trigger evidence, we don't have video. So they're gonna have to be comfortable convicting of conspiracy and convicting based on connecting the dots and circumstantial evidence. So Trina's done an excellent job. The evidence is absolutely all in that they need, but it depends on if they have one or two jurors who struggle with those concepts. And unfortunately, not being able to see their faces, not being able to see how they're reacting to evidence, I don't know if you have what we call sleepers on that jury.
Yeah.
I don't think we do. I think it's clear as day. I think the state did absolutely everything they needed to do. The question will be whether there's one or two of them that just need time to be convinced.
Yeah. All right, Rachel, thank you. Always a pleasure talking with Rachel Smith. We'll probably call on her next week after the verdict comes out, perhaps just to get her perspective, and then, use her expertise during the Brandon Boudreaux trial. So thank you very much, Rachel, for being here tonight. And of course, thank you all for watching. Charles Vallow, we are thinking of him tonight. And of course, next week, as the jury deliberates and comes down with a verdict in this particular trial. It's because of him that we're here, unfortunately, but we are thinking of him and all of the other victims in this case. Okay, we do have some shout outs and some questions tonight. Let me go to those. Here we go. Ginger Golden. Is that your real name, Ginger? Because that's an awesome name. Ginger Golden. Amy Smith. We know Amy Smith. Greg Witten. Abbey Road. Abbey Road. Really? I believe you. Tony Walker. Savannah Thomas. Katrina Raven. And I met a wonderful lady today outside the courthouse who gave me a birthday card. I want to shout you out too. I'm sorry I forgot your name and I could pull up the card. I have it here. So nice to meet you. I swear, we have the best audience ever. And I just wish that everyone could feel all of this love. And I know it's not about me. I hope that it doesn't appear that it's about me, but I really appreciate your support. We have people watching in Orlando, in Howey in the Hills, Florida. Just above Orlando, Howey in the Hills. Is that really what it's called? Or are you Howey and you're in the hills? That's the question. Indonesia, Germany, Australia, London, Connecticut, Ohio, Denmark, Arkansas, Cape Town, South Africa, and Michigan. Amazing, amazing that you all are watching this nerd in Arizona, soon to be Idaho. Let's go with some questions. Carol, was Lori charged with Social Security Administration fraud? She was not. Well, she was in Idaho. She was not here. But in Idaho, she was, what was the actual charge? It wasn't Social Security fraud. It was grand theft by deception, I believe. And then Chad was charged with insurance fraud, both found guilty. And that was for the money they were using on their children and their spouse. Cindy says, I started watching you when your newsfeed popped up on my YouTube videos right before you went to Hawaii to confront Lori. In fact, it might have been that video saying you were going to Hawaii. How did you actually get the tip? How did you start doing this story? Good question, Cindy. It was right before Christmas, the Friday before Christmas. We got a news release. Let me back up. I had heard several weeks before a source that I know, who's I trust, called and said, there's something crazy happening in Rexburg. It's going to come out. Just wait for it. And I'm like, oh, like a drug bust? He's like, no. And then someone else messaged me and said, have you heard about Tammy Daybell and her death? And I'm like, who's Tammy Daybell? And I pulled up her obituary and they said, that was that. Like, that was it. Friday before Christmas, I'm out doing some Secret Santa surprises with our staff when I get a call from my colleague, Nate. And he says, dude, we just got a really weird news release from Rexburg Police about 2 missing kids. I'm like, what? Get it up. Post it. Missing kid. That's huge. He's like, this one's weird, though. Like, it's 2 pages. The parents aren't cooperating. They're on the run. I'm like, what? And the story just grew 15 legs that second and just took off on a marathon sprint. We had an intern working with us. You might remember Eric Grossarth, great guy. He started digging into info that night on the internet. I went to a concert that night with my kids. They were in a children's choir concert in Rexburg, and everybody in the auditorium was talking about these missing kids and their parents. And then the next day, we got word that the police actually released pictures of the parents, and we posted those. And then I think within like 3 hours, we knew that from when the kids vanished, that Lori Vallow's husband was shot and killed in Arizona. Her brother had died the week before. Tammy Daybell was dead in October, and that these parents, no one knew where they were, at least publicly. The police, I think, knew they were in Hawaii. And we're learning this bit by bit. Like, you'll never guess her husband was killed. You'll never guess her brother died last week. You'll never guess Tammy Daybell, like one thing after another. Christmas was kind of slow in the news. I took some time off waiting to see what would happen. And then the new year came, and I think January 2nd, we met as a team. And I'm like, we really got to go in on this story. We got to go like all in and figure out. I went up to Fremont County, interviewed the sheriff, went to the house, did all that stuff. And then somebody sent us a tip as to where they were, Chad and Lori. And we didn't know how reliable and strong the tip was. And so we went to Hawaii, long story short, and we used you guys, the public, I kid you not. We were getting tips left and right as to Lori and Chad's whereabouts. They could not go anywhere. They couldn't go to Costco, get on a plane. Every place they went, we were getting tips until they were arrested. So really, you all are the sleuths that help me do my job. Donna asks, who's paying for Lori's legal team? The taxpayers are. They're public defense. They're with the Defense Department, the Maricopa County Defense Unit. So she doesn't have to pay for them. She doesn't have any money, but the public is. Why did Summer tell Lori what Adam was doing? I missed that story. It sounds awful. Then I remember you interviewing her and she was so sweet, when in reality, I just guess I'm confused, Amber says. That's a great question, Amber. I've reached out to Summer to see if she would be willing to do an interview to kind of speak about these things, because obviously they're things we hadn't heard before. I would imagine Lori was lying to the whole family, but I hope to talk to Summer, and maybe next week after the verdict comes in, and I'll share it here with you, and I will ask you a question, Amber. Ginger says, regarding the Lori Vallow Daybell case, if Lori was to testify, does the prosecution have to submit questions they're going to ask her before so she can prepare? Is and what is the prosecution allowed to ask? No, they don't have to submit questions. Whatever, so the defense would go first. They would ask Lori the questions that she prepares ahead of time, and then the prosecution can follow up on those questions, but they have to stay within the scope. They can't just throw everything in. They have to stay within what the defense asked, those types of questions. And they would not have to pre-submit them to Lori. Rex asks, why isn't Lori referred to as a serial killer? There were more than 3 victims. Well, I guess we'll see if she's found guilty on this one, then it will be 4 victims. But I guess you could call her that. I guess the technical definition is it 2 or more. Can the jury have all the text messages? And I know a lot of you get upset back to that I call her Lori. Honestly, it's for simplicity when reporting, because to call her Daybell, especially during Chad and Lori, when all that was tied together, it just, people were like, well, which Daybell? And then you've got Tammy Daybell, and then you've got the Daybell kids. It just was for simplicity. And in this case, Trina K, normally I would refer to people by their last names, call her K, but then people thought I was talking about Kay Woodcock, and they're like, why is Kay there asking questions? So I switched over to first names just for ease of reporting there, but there is a little bit of confusion. Can the jury have all the text messages when they go to deliberate, not just the text that Trina showed? They can only have what was admitted in evidence, and what was admitted in evidence was what we saw. There may have been some more. I don't know if she showed the whole exhibit, but if it was admitted, if she admitted all the text, they can do that. That would be a lot to admit and a lot for them to go through. But yeah, if she admitted them, they can. Who finally ended up paying for Charles's funeral service? I believe Kay Woodcock did. I'll have to check on that though. Can you put up a poll regarding whether we think the verdict will be based on the testimony that has been given so far? I don't know if we can do a poll on that, Cindy, but I think maybe on Monday after the closing arguments happen, we can maybe do a poll as to what time you think the jury will have a verdict. We'll have to see that. All right, I think that's it. Thank you all so much for watching. Here's where you can find me: Facebook, Insta, Twitter, X, and YouTube. We also have Meetin' the Eatons, and I'm thinking about, I need to ask Erica, maybe going live tomorrow night from home with Erica discussing the case. What do you think? Should we do it Friday night, just chit-chatting? We'll see. We might just want to unplug for the weekend, but we might just want to do it. I'll be back Sunday night. We're going to do a everything you need to know before the jury gets the case type of program. And then Monday, back in the courtroom for the big day, closing arguments. It's going to happen at 1 o'clock. The jury is going to get the instructions, I believe, at 10:30 or 11. And then they're going to break for lunch. And then it'll be go straight forward with closing arguments. First the state, then Lori, then the jury gets the case. Everybody, thanks for watching. I hope you have a great weekend. Happy Easter. Maybe we'll be back tomorrow. Maybe we won't. Just stay tuned. Subscribe to East Idaho News so you don't miss anything. Have a great weekend. Bye-bye.